I never imagined that painting my front door navy blue would trigger a legal battle that would expose an entire web of HOA corruption. But here we are, and I'm $20,000 richer because of it. My name is Henry Patterson, and I'd been living in Riverside Meadows, a planned community just outside Phoenix, Arizona, for about 3 years when this whole mess started. The neighborhood was nice enough. Rows of beige and tan houses with desert landscaping, the kind of place where everyone's lawn looked exactly the same and nobody really talked to each other much. I worked as a software developer from home, which meant I spent a lot of time staring at my house, and honestly, the builder's beige was starting to drive me crazy. The HOA rules were typical, or so I thought. Keep your grass trimmed, no boats in the driveway, nothing too crazy. I'd read through the covenants when I bought the place, and there was a section about exterior modifications requiring approval, but it also listed pre-approved colors for various home elements. Navy blue was right there on the approved list for front doors. I even triple-checked before I went to Home Depot. It was a Saturday morning in March when I painted the door. The weather was perfect, about 75 degrees with a light breeze. I took my time, did 2 coats, and it looked fantastic. The navy blue made the house pop in a way the bland beige never had. My neighbor across the street, an older guy named Bill, even came over to tell me it looked good. That was Saturday. By Monday afternoon, I had a letter in my mailbox. The envelope had the HOA logo on it, and inside was a violation notice signed by someone named Patricia Henderson, who apparently was the head of the Architectural Review Committee. The letter stated that my door color was unauthorized and violated community standards. I had 7 days to repaint it to an approved color or face fines of $50 per day. I stood in my driveway reading this thing 3 times, thinking maybe I was losing my mind. I went inside, dug out my copy of the HOA documents, and found the approved colors list. Navy blue, right there in black and white, listed under acceptable door colors. I took a photo of the page with my phone. The next morning, I called the HOA management company. A bored-sounding woman named Jennifer answered and transferred me to Patricia Henderson's voicemail. I left a detailed message explaining that navy blue was on the approved list and requested a call back. 2 days passed with no response. On Thursday, I got another letter. This one informed me that I now had 3 days remaining to fix the violation. There was no acknowledgement of my phone call, no explanation, just the same threat of daily fines. I called again, and this time managed to catch Jennifer before she could transfer me. "I need to speak with Patricia Henderson about a violation notice that's incorrect," I said. "Mrs. Henderson is very busy. If you received a violation notice, you need to correct the issue." "The issue is that there is no violation. Navy blue is an approved color according to the HOA documents." There was a pause. "Mrs. Henderson determines what is and isn't appropriate for the community. If she says your door is the wrong color, then it's the wrong color." I felt my jaw clench. "That's not how this works. There are written rules. I followed them." "You can appeal at the next board meeting," Jennifer said. "That's 3 weeks from now, 3 weeks. The letter says I have 3 days before fines start." "Then I suggest you repaint your door." She hung up. I sat there staring at my phone, genuinely stunned. I'd dealt with bureaucratic nonsense before, but this was something else. I wasn't about to repaint a perfectly good door just because some HOA board member decided she didn't like it, approved list or not. That weekend, I did some research. I found out that Patricia Henderson, who everyone called Patty, had been on the HOA board for nearly a decade. She'd been president of the Architectural Review Committee for 6 years. Online reviews of Riverside Meadows mentioned her name repeatedly, usually not in a positive way. There were stories about arbitrary violations, selective enforcement, and generally making residents' lives miserable over minor issues. I also learned that under Arizona law, HOAs had to follow their own governing documents. If they said navy blue was approved, they couldn't fine me for using it. I downloaded the Arizona Planned Communities Act and started reading. It was dense legal stuff, but I'm pretty good at parsing technical information, and I quickly realized that Patty and her committee were on shaky legal ground. Monday arrived, and so did another letter. This one informed me that my 7-day grace period had expired, and fines would begin accumulating at $50 per day starting immediately. I was also told that if I didn't correct the violation within 30 days, the HOA could file a lien against my property. That's when I decided I'd had enough. I wasn't going to be bullied by someone on a power trip. I drafted a formal letter, cited the specific page and paragraph in the HOA documents that listed navy blue as an approved color, referenced the relevant sections of the Arizona Planned Communities Act, and requested that the violation be withdrawn immediately. I sent it certified mail so there'd be proof of delivery. 3 days later, I got a response. Not a withdrawal of the violation, but a new letter stating that the approved colors list had been updated and navy blue was no longer acceptable. The letter was dated after I'd painted my door, but claimed the change had been made before. It was obviously backdated, and they weren't even trying to hide it very well. The document they attached as the updated list was a fresh PDF created the day before, according to the metadata I could see when I opened it on my computer. I sat at my kitchen table that evening, eating leftover Chinese food and reading this letter, and something in me just snapped. Not in an angry way, but in a clarity way. These people thought they could do whatever they wanted because most homeowners would just give in rather than fight. They were counting on apathy and intimidation. But I had time, I had documentation, and I was stubborn as hell. The next morning, I called a lawyer. His name was Marcus Brennan, and he specialized in HOA disputes. His office was in Scottsdale, and he could see me that afternoon. Marcus was probably in his mid-50s, with gray hair and the kind of calm demeanor that made you feel like everything would be okay. His office was lined with law books, and he had a collection of cacti on the windowsill. I showed him all the letters, the original HOA documents with the approved colors list, and the obviously backdated updated list. He read through everything methodically, occasionally making notes on a legal pad. When he finished, he looked up at me and said, "They're not very smart, are they?" "Is this as bad as I think it is?" "It's worse," Marcus said. "They can't retroactively change rules to create a violation that didn't exist when you took the action. That's basic contract law, and this backdating nonsense is potentially fraudulent. They've also failed to follow proper procedures for amending the covenants. Changes like this require notice to homeowners and usually a vote. Did you receive anything like that?" "Nothing." Then they're in clear violation of their own governing documents and Arizona law. He leaned back in his chair. "The fines they're threatening are unenforceable. If they try to collect, you have grounds for a lawsuit. In fact, you might have grounds regardless." "What do you mean?" "Arizona law allows homeowners to recover attorneys' fees and costs when an HOA violates the law or its own rules. You've already been harmed by their actions. You've had to spend time and energy dealing with this. You've had to hire me, and they're threatening your property with a lien." That's actionable. I felt a strange mix of vindication and anxiety. "So what do I do?" Marcus tapped his pen on the legal pad. We can go a couple of ways. Option 1, I send them a strongly worded letter explaining why they're wrong and threatening legal action if they don't back down. That works sometimes. Option 2, we skip the letter and file suit immediately. That sends a stronger message. What would you do based on these letters? Based on this backdating scheme, I'd file suit. People like this don't respond to strongly worded letters. They respond to process servers and court dates. We talked for another 30 minutes about strategy and costs. Marcus worked on contingency for cases like this, which meant he'd take a percentage of any settlement or judgment, but I wouldn't pay him hourly. Given that Arizona law allowed for fee recovery in HOA disputes, he was confident we'd come out ahead. I left his office feeling lighter than I had in days. By the end of the week, Marcus had drafted a lawsuit against the Riverside Meadows HOA, Patricia Henderson personally, and the management company. We were suing for harassment, violation of the Arizona Planned Communities Act, breach of contract, and attorney's fees. We weren't asking for a specific dollar amount yet, but Marcus said we'd easily clear $10,000 once we added up all the damages and fees. The lawsuit was filed in Maricopa County Superior Court on a Wednesday morning. By Friday afternoon, Patty Henderson was at my door. I saw her coming up the walkway through my window. She was exactly what I'd imagined. Mid-50s, severely cut blonde hair, wearing expensive athletic wear like she'd just come from a yoga class, and carrying herself with the kind of rigid posture that suggested she'd never been told no in her life. I opened the door before she could ring the bell. "Henry Patterson," she said, her voice clipped. "That's me. I'm Patricia Henderson, head of the Architectural Review Committee. I think we need to talk about this ridiculous lawsuit you've filed." I leaned against the doorframe. "I don't think we should talk at all, actually. My attorney advised me not to have direct contact with you." Her face flushed. "This is absurd. All of this over a door color. If you'd just been reasonable and repainted it, none of this would be necessary. Navy blue is an approved color according to the HOA documents. That list was outdated. It was the list in effect when I painted my door. You can't change rules retroactively." "I've been on this board for 10 years, Patty said, her voice rising. "I know what's appropriate for this community and what isn't. Your door stands out. It doesn't fit the aesthetic we've worked hard to maintain." "The aesthetic you mean is the one where you get to decide what everyone does with their own property regardless of what the rules say." Her eyes narrowed. "You're making a big mistake. This lawsuit is going nowhere and you're just wasting money on a lawyer. Drop it now, repaint your door, and we'll forget the fines." "No. Excuse me." I said no. "I'm not repainting my door, I'm not dropping the lawsuit, and I'm not paying fines for a violation that doesn't exist. If you want to have a conversation, you can contact my attorney. His information is on the lawsuit paperwork you received. Otherwise, please leave my property." Patty stood there for a moment, apparently unused to people standing up to her. Her face went through several shades of red before she finally turned and walked back to her car, a white BMW SUV parked at the curb. She drove off faster than the neighborhood speed limit allowed. I closed the door and immediately called Marcus to tell him what happened. He sighed. "I figured she might try direct contact. Don't worry about it. You did the right thing by refusing to engage. If she contacts you again, don't answer the door. Let everything go through me." Over the next few weeks, things escalated in ways I hadn't anticipated. First, I got a new violation notice, this time claiming my landscaping wasn't up to code. My landscaping was identical to half the houses on the street: desert plants, rock mulch, a small patch of grass. I took photos of every yard in a 3-block radius that looked exactly like mine. None of them had violation notices. Then I got cited for leaving my trash cans visible from the street. The citation came on a Thursday. Trash day was Friday. The cans had been out for maybe 6 hours. Marcus added each new violation to our lawsuit, amending it to include a pattern of harassment and selective enforcement. Each amendment made our case stronger and, frankly, made the HOA look worse. About a month after filing the lawsuit, we got the HOA's response. Their attorney, a guy named Robert Sheffield from a firm that specialized in defending HOAs, filed a motion to dismiss, arguing that we hadn't exhausted administrative remedies and that the lawsuit was frivolous. Marcus had expected this. We filed a response pointing out that administrative remedies were meaningless when the HOA was acting in bad faith and violating its own rules. We attached all the documentation, including the backdated approved colors list, with its metadata showing when it was actually created. The judge denied the motion to dismiss. That was a good day. Marcus called me that afternoon, and I could hear the smile in his voice. Judge Ramirez wasn't impressed with their arguments. We're moving forward. Discovery starts next week, which means we get to request all their internal documents, emails, meeting minutes, everything. Will they actually hand that stuff over? They have to. If they don't, they'll be in contempt. And trust me, once we see their internal communications, we're going to find more ammunition. He was right. The discovery process took about 6 weeks, and what we found was stunning. It turned out that Patty Henderson had a long history of arbitrary enforcement. There were emails where she specifically talked about targeting homeowners she personally disliked. There was a spreadsheet tracking violations by address, and it was immediately obvious that certain homes got cited for things while others didn't, with no consistent standard. Most damning was an email exchange between Patty and another board member named Susan Cross. In it, Patty explicitly stated that she didn't like my door color regardless of whether it was on the approved list, and Susan replied suggesting they update the list and backdate it. There it was in writing, premeditated fraud. Marcus was ecstatic when he read that email. This is exactly what we needed. They documented their own misconduct. I've seen HOA cases go south because you can't prove intent, but they literally wrote down their plan to create a fake violation. We weren't the only ones who found interesting things during discovery. The HOA's attorney must have realized how bad his clients looked, because we got a settlement offer the next week. The HOA would withdraw all violations, promise not to bother me about my door, and pay $5,000 to cover my attorney's fees. Marcus called me to discuss it. It's not a bad offer, honestly. You'd be done with this, they'd leave you alone, and we'd get paid for our time. What do you think I should do? That's entirely up to you, but I'll tell you what I'd do if I were in your position. What's that? I'd tell them to shove it. We have them dead to rights. Those emails are smoking guns. If we go to trial, we're going to win, and we're going to win big. Plus, there's something to be said for holding people accountable. Patty Henderson has been terrorizing homeowners for years. A slap on the wrist doesn't change that. I thought about Bill across the street, who'd mentioned having his own problems with the HOA. I thought about the online reviews I'd read, all the people who'd given in rather than fight. I thought about the principle of the thing. Let's keep going, I said. Marcus drafted a rejection of their settlement offer. We countered, demanding $20,000 in damages and fees, a formal written apology, removal of Patricia Henderson from the Architectural Review Committee, and a court order preventing the HOA from any retaliatory actions. Their attorney responded with outrage, calling our counteroffer unreasonable and threatening to take the case to trial where we'd supposedly be embarrassed. "Bring it on," Marcus said when he read the response. Trial was scheduled for September, about 5 months after I'd first painted my door. As the date approached, the HOA made one more settlement attempt, this time offering $10,000. We rejected it. They came back at $15,000. We rejected that too. "They're panicking," Marcus explained. "They know those emails are going to look terrible in front of a judge. Plus, we're going to call Patty Henderson to testify, and I guarantee she's going to be a disaster on the stand. People like her can't handle being questioned." A week before trial, something unexpected happened. I got a knock on my door around 8 in the evening. It was Bill from across the street, and he had another man with him I didn't recognize. "Hey, Henry, you got a minute?" Bill asked. "Sure, come in." They introduced themselves. The other man was named Dennis Rodriguez, and he lived 2 streets over. Both of them had heard about my lawsuit through neighborhood gossip, and they wanted to talk. "I got fined $300 last year," Dennis said. "Patty claimed my house needed repainting because it was faded. My house looked exactly like everyone else's. I paid the fine because I couldn't afford a lawyer and I was worried about a lien." Bill nodded. "She cited me for having a crack in my driveway. A tiny crack, maybe 2 inches long. Said it was a safety hazard and I had to repave the whole driveway. That's thousands of dollars. I ended up paying someone to fill it with concrete patch, and she still made me pay a $200 fine. We talked for over an hour. They told me stories of other neighbors who'd been targeted, arbitrary rules that seemed to only apply to certain people, and a general atmosphere of fear around the HOA. Nobody wanted to fight because fighting meant time and money and risk. "The thing is," Bill said, "if you actually beat them in court, it would mean something. It would show people they can't just do whatever they want." I told them I'd already rejected multiple settlement offers and was going to trial. They both looked relieved. "Good," Dennis said. "Someone needs to stand up to her." Trial started on a Tuesday morning. The courthouse in downtown Phoenix was busy, people in suits rushing around with briefcases and files. Marcus met me outside the courtroom looking calm and confident. The HOA's attorney, Sheffield, was already inside with Patty Henderson and 2 other board members. Judge Ramirez was a no-nonsense woman in her 60s who'd been on the bench for 20 years, according to Marcus's research. She ran a tight courtroom and didn't tolerate games. The trial started with opening statements. Marcus laid out our case clearly. I'd painted my door an approved color. The HOA had violated its own rules and Arizona law by creating a fake violation, and they'd engaged in harassment and selective enforcement. He mentioned the emails showing premeditation. Sheffield's opening was weaker. He argued that the HOA had a right to maintain community standards, and that any procedural irregularities were minor and made in good faith. The first witness was me. Marcus walked me through the timeline, buying the house, reading the HOA documents, painting the door, receiving the violation notices. I kept my answers clear and factual. Sheffield's cross-examination tried to paint me as difficult and unreasonable, but it didn't land. I'd followed the rules. There wasn't much he could do with that. Next, Marcus called Jennifer from the management company. She was visibly uncomfortable on the stand. Under questioning, she admitted that she'd never actually checked whether navy blue was an approved color before sending out violation notices. She just processed whatever Patty told her to process. "So you don't independently verify violations?" Marcus asked. "Not usually, no. The board tells us what to do and we do it. Even if what they're telling you to do violates the HOA's own rules. I assume they know what they're doing." It was a damning admission of rubber stamping whatever the board wanted. Then came the moment I'd been waiting for. Patty Henderson took the stand. She was wearing a business suit and had her hair pulled back severely. She looked like she was trying to project authority, but there was tension in her jaw. Marcus started with basic background questions: how long she'd been on the board, her role on the architectural review committee, that sort of thing. Then he moved to the door. Mrs. Henderson, when did you first become aware of Mr. Patterson's door color? The Monday after he painted it. I drive through the neighborhood regularly to check for violations. And you immediately determined it was a violation? Yes. The color was inappropriate. Inappropriate in what way? It stood out. It didn't match the community aesthetic. Marcus nodded slowly. But according to the HOA's approved colors list in effect at that time, navy blue was an acceptable door color, correct? Patty shifted in her seat. That list was outdated. When was it updated? I'd have to check the exact date. Marcus pulled out a document. I have here the approved colors list from the HOA's governing documents, recorded with the county in 2015. Navy blue is listed. I also have the updated list you sent to Mr. Patterson. According to the metadata, this document was created on March 27th of this year. Mr. Patterson painted his door on March 17th. Can you explain how a list created 10 days after he painted his door means the list in effect when he painted it was outdated? The courtroom was silent. Patty's face went red. The list was, we discussed updating it before that. But you hadn't actually updated it. It was in process. So when Mr. Patterson painted his door, navy blue was in fact an approved color. Technically, yes, but yes or no, Mrs. Henderson? Yes. Marcus let that hang in the air for a moment. Then he pulled out another document. I'd like to enter into evidence an email dated March 26th, the day before the updated list was created. This is an email from you to board member Susan Cross. Would you like to read it, or should I? Patty looked like she wanted to disappear. I don't recall that specific email. Allow me to refresh your memory. Marcus read aloud. Susan, that guy on Maple Street painted his door blue and it looks terrible. I don't care if it's on the approved list, I want it changed. Can we update the list and backdate it? Nobody ever checks these things anyway. The courtroom felt like all the air had been sucked out. Even Sheffield looked uncomfortable. Mrs. Henderson, did you write this email? Patty's mouth opened and closed. That's out of context. What context makes deliberately backdating a document to create a violation acceptable? I was frustrated. I didn't mean it literally. But you did backdate the document, didn't you? The metadata shows it was created on March 27th, but it's dated March 1st. We must have selected the wrong date by accident. Marcus spent the next 30 minutes methodically destroying her credibility. He brought up the other violation notices I'd received, showing the selective enforcement. He presented evidence of other homeowners who'd been similarly targeted. By the end, Patty looked exhausted and defeated. Sheffield tried to rehabilitate her on redirect, but there wasn't much he could do. The emails were clear, the timeline was clear, and her testimony had been evasive and unconvincing. The trial lasted 2 days. On the second day, Marcus called an expert witness, a property management consultant who testified about standard HOA practices and how the Riverside Meadows HOA had violated basically all of them. Sheffield called a board member who tried to defend their actions, but under cross-examination admitted she hadn't actually read the governing documents in years, and basically just went along with whatever Patty wanted. Closing arguments were straightforward. Marcus laid out how we'd proven every element of our case: breach of contract, violation of Arizona law, harassment, and selective enforcement. He asked for $20,000 in damages and fees, plus injunctive relief. Sheffield argued that we were overreacting to a simple misunderstanding, and that $20,000 was excessive. It was a week close. Judge Ramirez said she'd issue a ruling within 2 weeks. Those 2 weeks were some of the longest of my life. I tried to focus on work, but I kept thinking about the trial, replaying testimony in my head, wondering if we'd done enough. Marcus called me on a Thursday afternoon, exactly 13 days after closing arguments. "We won," he said simply. I sat down at my kitchen table. Everything. Judge Ramirez issued a 32-page ruling that absolutely eviscerates the HOA. She found that they violated their own governing documents, violated Arizona law, engaged in fraud through the backdating scheme, and selectively enforced rules in a harassing manner. She awarded us $20,000 in damages and attorney's fees, ordered the HOA to remove Patricia Henderson from any leadership position, and issued an injunction preventing them from any retaliation. $20,000, I said, still processing. The judge specifically noted the emails as evidence of bad faith. She called the backdating scheme a deliberate attempt to manufacture a violation where none existed, and said selective enforcement showed a pattern of arbitrary and capricious decision-making. "Henry, this is one of the strongest rulings I've seen in an HOA case." We talked for a few more minutes about next steps. The HOA had 30 days to appeal, but Marcus doubted they would. The ruling was thorough and well supported. An appeal would just cost them more money they'd likely lose anyway. He was right. 3 weeks later, I received a check for $20,000 and a formal letter from the HOA board, signed by all members except Patty Henderson, apologizing for the violation notices and confirming that my door color was approved and that no further action would be taken. Patty resigned from the board entirely 2 days after the ruling came down. Rumor through the neighborhood was that she'd moved out of Riverside Meadows entirely within a month, though I never confirmed that. I didn't really care where she went, as long as she wasn't harassing people anymore. The aftermath was interesting. Once word got around about the lawsuit and the ruling, several other homeowners contacted Marcus about their own issues with the HOA. Some of them ended up getting refunds for fines that had been improperly assessed. The new Architectural Review Committee chair, a reasonable guy named Tom who lived a few streets over, went through all the recent violations and reversed about 30% of them as improperly issued. Bill came over one evening a few weeks after everything was settled, carrying a 6-pack of beer. "I wanted to say thanks," he said. "That ruling changed things around here. People aren't scared of the HOA anymore. The new committee is actually following the rules." We sat on my back patio, drinking beer and watching the sun set over the desert. It was nice, peaceful in a way the neighborhood hadn't felt in a while. "I didn't do it to be a hero," I said. "I just wanted to keep my door blue." Bill laughed. "Yeah, but sometimes standing up for something small means something bigger. You showed people they don't have to just take it when someone with a little bit of power decides to abuse it." I thought about that for a while. He wasn't wrong exactly. The lawsuit had started as a personal grievance, me being stubborn about a door color. But it had turned into something more, a line in the sand against arbitrary authority and petty tyranny. The $20,000 was sitting in my bank account, minus Marcus's contingency fee. I'd netted about $14,000 after his cut, which seemed fair given the work he'd put in. I wasn't sure what I'd do with it yet. Part of me wanted to do something visible, maybe upgrade my landscaping or add some nice outdoor furniture, just to thumb my nose at the old regime. But mostly I was just glad it was over. Dennis stopped by a few days after Bill's visit. He wanted to know if there was any way to get his $300 back from the previous year. I gave him Marcus's number, and last I heard, the new board had agreed to refund him without a fight. They were trying to avoid any more lawsuits or bad publicity. Life in Riverside Meadows settled into a new normal. The HOA still existed, still sent out the occasional violation notice, but they were legitimate now. Grass that actually was overgrown, genuine safety hazards, that kind of thing. The reign of arbitrary enforcement was over. I kept the door navy blue, obviously. It still looked great, and now it meant something more than just a color I liked. It was a reminder that rules matter, that documentation matters, and that standing up to bullies is worth the effort even when it seems easier to just give in. Marcus and I stayed in touch. He sent me a nice bottle of whiskey after the ruling became final, with a note that said, "Thanks for being stubborn. We need more clients like you." I sent him a Christmas card that year with a photo of my front door prominently featured. The case also got some local media attention. A reporter from the Arizona Republic wrote a piece about HOA abuses and featured my lawsuit as an example. That led to some state legislators talking about reforming HOA laws to give homeowners more protection. I don't know if anything will actually come of that, politics being what they are, but it felt good to contribute to a larger conversation. One unexpected benefit was that property values in Riverside Meadows actually went up slightly after the lawsuit. Apparently, potential buyers liked seeing that the HOA had been reined in and was now operating more reasonably. Real estate agents started mentioning the reformed HOA as a selling point. Who knew that getting sued could be good for business? I ran into Susan Cross, the board member who'd been part of the email exchange with Patty at the grocery store about 6 months after the trial. She was in the produce section, and we made eye contact. For a second, I thought she might try to avoid me, but instead she walked over. "I owe you an apology," she said without preamble. "I went along with Patty on a lot of things I shouldn't have. I knew what we were doing with that colors list was wrong, and I did it anyway. I'm sorry." I was surprised by her directness. "I appreciate you saying that." I resigned from the board after the ruling. I didn't feel right staying on after everything that came out. I just wanted you to know that I learned something from this whole mess. Rules exist for a reason, and you can't just ignore them because you feel like it. We talked for a few more minutes. She seemed genuinely remorseful, and I got the sense that she'd been more of a follower than a leader in the whole scheme. That didn't excuse her actions, but I could at least understand how it happened. Patty had been a dominating personality, and Susan had taken the path of least resistance. As the 1-year anniversary of painting my door approached, I decided to do something to commemorate the whole experience. I invited Bill and Dennis and a few other neighbors over for a barbecue. We set up in my backyard, grilled burgers and hot dogs, and just had a nice, normal afternoon. At some point, Bill raised his beer and said, "To Henry and his blue door, may it never need repainting." Everyone laughed and drank to that. It was a small moment, but it felt significant. A neighborhood coming together, freed from the shadow of a petty tyrant, just people being neighborly. Marcus showed up later with his wife, Alina. I'd invited him on a whim, and I was glad he came. He and Alina were fun, easy to talk to, and they had their own HOA horror stories from when they'd lived in Temp years ago. It turned out Alina was also a lawyer, working in family law, and she had some stories that made our HOA case look tame by comparison. As the sun set and people started heading home, I found myself sitting on my back patio alone, looking at the lights of Phoenix in the distance. I thought about the last year, everything that had happened, and I felt something I hadn't expected: gratitude. Not gratitude for the hassle or the stress or the time spent in court, but gratitude for the reminder that standing up for yourself matters, that systems only work when people hold them accountable, and that sometimes being stubborn about something small can lead to something meaningful. My phone buzzed. It was a text from Marcus. "Thanks for having us over. Alina and I had a great time. By the way, got a call today from another Riverside Meadows homeowner. Different issue, but they mentioned your case as inspiration. This is becoming a thing." I smiled and texted back, "Happy to be the neighborhood troublemaker." He replied with a laughing emoji and, "Troublemaker nothing. You're the guy who proved they could be beaten. That's worth something." He was right. It was worth something. Not just the $20,000, though that was nice. But the principle, the precedent, the idea that people didn't have to accept abuse from petty bureaucrats just because fighting back was hard. The next morning, I was working at my home office when I heard someone at the door. I looked out the window and saw a younger couple I didn't recognize. I opened the door. "Hi, are you Henry Patterson?" the woman asked. She looked nervous. "That's me." "I'm Rachel, and this is my husband Mike. We just bought the house 3 doors down. We heard about your lawsuit with the HOA and we wanted to introduce ourselves. And also, we wanted to ask you something." "Sure, come in." We sat in my living room and they explained their situation. They wanted to install solar panels, which the old HOA regime had routinely denied even though there was no prohibition in the governing documents. They were worried about getting the same runaround I'd gotten. "The new committee is supposed to be better," Rachel said, "but we're still nervous. Do you have any advice?" I thought about it. Document everything. Read the governing documents yourself. Don't just trust what the HOA tells you. If solar panels aren't prohibited, and they probably aren't, you have a right to install them under Arizona law. There's actually a state statute about that. If they deny you, get a lawyer immediately. Don't let them bully you. Mike nodded, taking notes on his phone. "And if you don't mind me asking, was it worth it? The lawsuit, I mean, was it worth all the stress and time?" I looked at my navy blue front door visible through the window. "Yeah," I said, "it was worth it." They thanked me and left, and I went back to work. But I found myself thinking about that question. Was it worth it? The answer was complicated. The lawsuit had been stressful. It had taken time and energy I could have spent on other things. There had been moments when I'd wondered if I should just repaint the damn door and move on with my life. But I hadn't, and I was glad, because it wasn't really about the door. It was about the principle that rules should mean something, that people with power should be held accountable, and that ordinary people can fight back against abuse and win. The money was nice. The vindication was nice. But the best part was knowing that the neighborhood was better off now than it had been before. The HOA still existed, still served its legitimate functions, but it no longer operated as a tool for personal vendettas and arbitrary enforcement. A few months later, I got an email from a homeowner advocacy group based in Colorado. They'd heard about my case and wanted to feature it in their newsletter as an example of successful resistance to HOA abuse. They asked if I'd be willing to do a phone interview. I agreed and spent an hour talking to a reporter named Jennifer about the whole experience. She was particularly interested in the backdating scheme and how we discovered it through the document metadata. "That's such a specific detail," she said. "Most people wouldn't know to check that." "I work in tech," I explained. "I'm used to looking at file properties and metadata. It's second nature. But yeah, I think most people wouldn't catch it, which is probably why they thought they could get away with it." The article came out a few weeks later, and I was surprised by the response. I got emails from people all over the country who'd had their own HOA nightmares. Some were looking for advice, others just wanted to share their stories. It was eye-opening how common these problems were. One email that stuck with me was from a woman in Florida whose HOA had fined her $5,000 for planting the wrong kind of flowers. She'd fought it, lost, and ended up paying just to avoid a lien on her house. Reading her story made me realize how lucky I'd been to find Marcus, to have the time and resources to fight, and to win. I started thinking about ways to help other people in similar situations. I wasn't a lawyer and couldn't give legal advice, but I could share information. I put together a document outlining what I'd learned. The importance of reading governing documents, documenting everything, checking state laws, looking for inconsistencies in HOA actions, and finding a good lawyer early. I shared the document with the homeowner advocacy group, and they posted it on their website. It got downloaded hundreds of times in the first month. People started emailing me thank you notes, telling me they'd use the information to push back against their own HOAs. It felt good, like the experience had turned into something useful beyond just my own situation. Life continued. Seasons changed. The Phoenix summer came and went, brutal as always. My door weathered the heat just fine, the navy blue paint holding up perfectly. I'd used good quality exterior paint, and it showed. The following spring, almost exactly 2 years after I'd first painted the door, I got an invitation to speak at a conference on HOA reform in Las Vegas. The organizers had read about my case and thought my perspective would be valuable. I'd never been a public speaker, but I figured why not? The conference was small, maybe 200 people, mostly homeowners with their own HOA horror stories and some lawyers and advocates. I gave a 20-minute talk about my experience, focusing on the importance of standing up for your rights and not being intimidated by organizations that seem powerful but are actually bound by their own rules. The response was enthusiastic. During the Q&A, people asked detailed questions about the legal process, how to find a good lawyer, how to stay motivated during a long dispute. I did my best to answer, drawing on what I'd learned. After my talk, a man in his 70s approached me. His name was George, and he had tears in his eyes. "Thank you," he said. "My wife and I have been fighting our HOA for 3 years over a disability ramp we installed. They say it's not approved, but we had a doctor's note and everything. We were about to give up, but hearing your story, I think we're going to keep fighting." I shook his hand. "Don't give up. If you're in the right, keep pushing. Find a good lawyer. Document everything. You can win." He nodded, wiping his eyes. "We will, thank you." Moments like that made everything worthwhile. The stress, the uncertainty, the hours spent dealing with legal documents and court dates. If my experience helped other people stand up for themselves, then it meant something beyond just my own situation. Flying back to Phoenix that evening, I looked out the airplane window at the lights below and thought about the strange journey I'd been on. It had started with something so simple, wanting to paint my front door a color I liked. It had turned into a legal battle, a neighborhood transformation, and apparently a minor role in a broader movement for HOA reform. I wasn't naive enough to think one lawsuit had changed everything. HOAs across the country were still abusing their power, still making people's lives miserable over trivial nonsense. But maybe my case had made a small difference. Maybe it had shown a few people that they didn't have to accept abuse, that they could fight back and win. That seemed like enough. Back home, I settled back into my routine. Work, life, the occasional neighborly barbecue. The HOA continued to exist in the background, doing its job in a much more reasonable way than before. I barely noticed them most of the time, which was exactly how it should be. Bill retired and moved to Oregon to be closer to his kids, but we stayed in touch. Dennis became the new president of the HOA board, which felt like poetic justice. He ran it fairly and by the book, and the neighborhood thrived under his leadership. Tom, the architectural review committee chair, stopped by one afternoon to ask if I'd be willing to join the committee. I laughed and politely declined. "I appreciate the offer," I said, "but I think I've had enough HOA drama for one lifetime." He understood. "Can't blame you. But for what it's worth, things are different now. We actually follow the rules, we're consistent, and we try to work with homeowners instead of against them. A lot of that is because of what happened with your case. It was a wake-up call. I'm glad something good came out of it." "More than something," Tom said. "You probably don't realize how bad it was before. Patty ruled that board with an iron fist. People were genuinely afraid to do anything with their property without permission, even things that were clearly allowed. You broke that fear. That's no small thing." After he left, I sat on my front porch looking at my navy blue door. It was just a door, really, just paint on wood. But it had become a symbol of something larger. The idea that ordinary people can stand up to unjust authority and win, that rules should be applied fairly, and that courage sometimes means simply refusing to back down when you know you're right. The sun set, painting the sky in shades of orange and purple. Another day in Phoenix, another evening in Riverside Meadows. Everything looked normal, peaceful, exactly as it should be, and my door was still blue.